As a journalist, you may want to protect the anonymity of your sources. But do you have a legal right to do so? The MEAA Journalist Code of Ethics provides in Clause 3 that where a source seeks anonymity and a journalist accepts that confidence, then that should be respected in all circumstances. This is a strong ethical and professional expectation, but the MEAA Code does not have any legal status. Where your story is pertinent to a legal case, you may be required by a court to disclose the identity of your sources. This is rare, and courts are generally reluctant to require journalists to disclose the identity of their anonymous sources. But it can happen. Australian courts have granted no special privileges to journalists, and the interests of justice and the due administration of justice will generally override any promises of confidence that you have made to your source. To refuse to identify a source when ordered to by a court is potentially disobedience contempt and a breaking of the law. Some journalists have even faced jail time for disobedience contempt for refusing to identify a source. Again though, this is rare and the jail time is usually quite short. Some Australian jurisdictions have passed so-called shield laws, which apply to journalists who seek to protect the identity of their sources. There is a federal law, as well as laws in New South Wales, Victoria, Western Australia, the ACT and Tasmania. Importantly though, Queensland has not passed any shield laws. For example, the Evidence Amendment Journalist Privilege Act of 2011 amends the Federal Evidence Act to insert Section 126 capital H. This section provides that if a journalist has promised an informant not to disclose their identity, then neither the journalist nor their employer can be compelled to do so. For the shield law to apply, the journalist must have guaranteed anonymity to their source. But critically, the shield can be overridden by a court if the court considers that the public interest in the disclosure of evidence outweighs any likely adverse effects of the disclosure on the informant, and outweighs the public interest in the ability of the news media to access sources and report facts. Finally, you should be aware of provisions in the Telecommunications Interception and Access Act, which may apply to your interactions with sources over the phone or computer. That Act was amended in 2015 to include requirements that telecommunications providers retain customers' phone and computer metadata for 2 years in case they are needed by criminal law enforcement agencies. Metadata includes information such as the name and other identifying information of the account holder, the source and destination of a communication, and the date, time, and duration of a communication. However, the Act also includes special protections for journalists. The Journalist Information Warrant Scheme ensures that metadata which may identify a journalist's confidential source cannot be disclosed without special precautions, including the approval of the Minister. So where does that leave you? The Code of Ethics that applies to your profession states that assurances of anonymity should always be respected, and shield laws in many Australian jurisdictions protect those confidences under law. But these rules can be overridden by a court order to disclose a source, and refusing to do so may see you facing charges for contempt of court.